Hello, everyone. Please be welcome to this webinar on the law of the sea matters. Good morning in Mexico City and good afternoon in Lisbon, in Portugal. At the outset, I would like to thank the Diplomatic Academy of Portugal, Instituto Diplomático, and his director, Ambassador José de Freitas Ferraz, for partnering with the Instituto Matías Romero, the Mexican Diplomatic Academy, in promoting the knowledge of the international law. I want to thank also to the Office of the Legal Counsel of the Ministry of Foreign Affairs in Mexico for the support provided for this webinar. Both countries, Mexico and Portugal, have been historically active players at the international level in promoting the law of the sea. A month ago, both diplomatic academies agreed to organize a session to one main purpose, to raise awareness to the new generations of diplomats of the importance of the law of the sea, and in particular, the relevance of the continental shelf. If you think in the rights of the coastal states, and when you think in a modern maritime delimitations, both topics very important to the international relations nowadays. We have two experts, one from Mexico and one from Portugal, and I have the honor to introduce first the Mexican expert, Mr. Galo Carrera Hurtado. After his presentation, the Ambassador Freitas Ferraz will introduce the Portuguese expert, Vasco Becker-Weinberg. Galo Carrera, he is a research associate in sea affairs at the Dalhousie University in Halifax in Canada, visiting professor at the World Maritime University in Malmö in Sweden, and a member of the International Association for Geodesy, a UN maritime demarcation expert on the law of the sea, and after being elected member since 1997, in 2010 he was appointed chairman of the UN Commission on the Limits of the Continental Shelf, the CLCS. He served as the secretary of the United Nations Committee for Geodetic Aspects of the Law of the Sea, as well as a member of the UN Advisory Board on the Law of the Sea. He has authored and co-authored nearly 200 scientific articles and technical reports, and has presented also articles and delivered academic speeches at international conferences, seminars, and courses practically all over the world in the 5 continents. His areas of research, geodetic and hydrographic methodologies for the delimitation of international territorial and maritime borders, scientific and technical determination of the outer limits of maritime spaces under national jurisdiction, including the continental shelf beyond 200 nautical miles, implementation of the regulations regarding the seabed mining activities in the UN Convention on the Law of the Sea, the UNCLOS, statistical analysis of information on sea level, rivers and lakes, and investigation of mathematical models for the determination of movements of the Earth's crust. So we are before a really internationally recognized expert, Galo Carrera, who has been also a very good partner of the Mexican government in the processes for their own delimitations of the continental shelf in the Gulf of Mexico. Galo, thank you very much for being with us, and you have the floor, please.
Thank you very much, Alejandro, Alday. Hello to everybody. Good morning in Mexico. Good afternoon in Lisbon. Good evening everywhere else around the world. I am very glad to be with you today and appreciate the invitation by both institutions to give this presentation. I am going to start by sharing my screen with you to show you the topic of the presentation, which is the legal regime of the continental shelf, both its development and implementation by Mexico since 1945 to 2021. It is important to start with a little bit of history. And whereas in many books around the world, you find that the proponent of the alleged proponent of the term continental shelf for the first time in science is Hugh Robert Mill. You'll find out in many texts, particularly relating to the legal concept of the continental shelf. The reality is that he's not the author of the concept itself. A year earlier, John Murray, in its scientific report of the voyage of the HMS Challenger, employed the term for the first time. And of course, he looked at it from the perspective of the 200-meter isobath. So I'm going to try to take you on a tour of topics that developed in between 1942 and 1972. The first time that any maritime claim relating to submarine areas takes place is in 1942 in the Gulf of Paria agreement between Venezuela and the United Kingdom. It was followed by the Truman proclamations, particularly 2667, which is the proclamation on the continental shelf. Then from 1945 to 1952, following the US proclamation, Mexico was the first country to declare a continental shelf, and it was followed by Argentina in 46 and a whole number of other countries very rapidly adopting in practice the establishment of the legal regime of the continental shelf up to 1952. Then the next following work that was important in the development of the concept of the continental shelf was the work developed by the International Law Commission between 1951 and 1956 in preparation of the Geneva Convention, the first, what we call now the first convention on the law of the sea. Of course, there were reunions and meetings, particularly in Latin America. In 1956, in Caracas, a specialized Inter-American Conference on the continental shelf took place, which basically supported the development of the regime of the continental shelf. And the first conference took place in 1958, where the outer limit of the continental shelf was established up to a distance of 200 meters. We call it in hydrography the 200-meter isobath of equal depth. That's a line of equal depth. In the Geneva Convention on the continental shelf. I would like to add that Mexico is particularly proud of its delegation that participated in the 1958 first conference on the law of the sea. It was led by Don Alfonso Garcia Robles, a recipient of a Nobel Prize, and the part relating to the continental shelf was led by another great Mexican jurist, Don Antonio Gomez Robledo. In 1960, following the Convention of 58, Mexico made its first amendment of its constitution, amending Articles 27, 42, and 48, introducing the concept of continental shelf in our constitution. And of course, you know that in 1960, the second UN Conference on the Law of the Sea, which resulted in an unsuccessful event, did not lead to the adoption of any treaty. In 1965, Mexico the President of Mexico issues a decree that establishes the outer limit of the up to a distance of 200 meters isobath or exploitability. And here, both since 1958 and 1965, you begin to see a movement away from what we call the scientific concept of the continental shelf. The continental shelf in science is a location, as we will see later on, where the depth reaches about 200 meters. The moment that the criteria of exploitability begin to be incorporated into first the Convention of 1958 and then later in the Mexican legislation, we obviously are expanding that scientific concept into what became then a legal concept of the continental shelf, which exceeded the 200-meter isobath. In 1969, we have a pivotal case in international case law. Of course, the North Sea continental shelf cases between Germany, Denmark, and the Netherlands helped interpret the notion and the legal concept of the continental shelf. And in 1972, a specialized conference took place in Santo Domingo in Dominican Republic, where the Latin American states united to try to propose the expansion of the concept of continental shelf beyond the concept of 200 meters. It's the first time that the concept of 200 meters and exploitability begins to be explored with a view to try to expand it. This is the Minister of Foreign Affairs of Venezuela to the left signing. The man to his right is the then president of Venezuela. He is the brilliant negotiator who negotiated the treaty between the United Kingdom and Venezuela relating to submarine areas. They also recovered an island in those negotiations at that time from the United Kingdom. And of course, the continental shelf is born officially in 1945 with the Truman Proclamations of 2667 on the continental shelf, and then the one 2668 on the coastal fisheries in certain areas of the high seas. I wish to make a brief stop in this part of the presentation to say that this Truman Proclamation was intended to become a Roosevelt proclamation, and it was going to be a single proclamation. This was done at instance of the then Secretary of the Interior, who passed it on the initiative to President Roosevelt, and President Roosevelt accepted the initiative to protect the fisheries in the Gulf of Alaska from foreign fishing. So it was a measure to try to protect the fisheries that led the initiative by the Ministry of the Interior to have this proclamation. Instead of being a single proclamation that could encompass a maritime space that took care of the resources in the seabed and subsoil, it was separated into two. And it was separated into two because once it was a task that had to be taken forward, it was passed on to the Department of State. And the Department of State of the United Nations took into consideration the fishing interest of the American fleets long range, away from the coast of the United States, not only to defend its own maritime spaces, but to have the ability to fish nearby the coast of other states. And that's how those two proclamations are born, one that establishes agreements, bilateral agreements between the United States and other states, and then the one on the continental shelf that includes exclusive rights of exploration and exploitation over the natural resources in the seabed and subsoil. Mexico is the first country to follow the United States in 1945. President Avila Camacho made a declaration, and it was followed all the way to 1952 by Bulgaria and Israel. Taking the concept of the legal development of the continental shelf between 1973 and 2000, we have to take into consideration the developments that took place in the third conference on the UN Law of the Sea. Mexico itself agreed to a boundary with the United States in the Gulf of Mexico in what we call the Western Polygon. I will show you a map later on. Up to the polygon, between 12 nautical miles and 200 nautical miles, a boundary was determined in the Gulf of Mexico and also in the central part of the Gulf of Mexico and in the Pacific Ocean. Those were exclusive economic zone boundaries, which also delimit the continental shelf. In 1982, of course, Mexico and many other states signed the United Nations Convention on the Law of the Sea, already adopting a new limit for the continental shelf that goes to up to 200 nautical miles or beyond that to the outer edge of the continental margin. Mexico adopts in 1985 in the Federal Law of the Sea all the provisions contained in the convention, including the extension of the continental shelf up to 200 nautical miles, mostly in the Pacific and the Caribbean, and up to the outer edge of the continental margin in the Gulf of Mexico. The first election of the Commission on the Limits of the Continental Shelf takes place in 1997, and 21 of us who had never been together in any event from different professions, from different backgrounds, with different histories, managed to end up with the adoption of rules of procedure of the Commission, perhaps one of the key documents in the history of the continental shelf, and particularly its Annex 1, which examines, at the request of the meeting of states parties, cases of disputes, territorial or maritime disputes among states. In 1999, the scientific and technical guidelines of the Commission were adopted. And finally, that was truly the start point in which states could confidently begin to prepare their submissions, because they had a good idea what was expected from them in terms of scientific data and information and the structure that a submission could have. And of course, in 2000, Mexico reaches another boundary agreement, this time with the United States beyond 200 nautical miles in what we call the Western Polygon. The last stage takes us in this century between 2001 and 2021, with the second election of the Commission in 2002, the third election in 2007, and Mexico makes its first submission. It makes a partial submission for the Western Polygon. And here I am going to highlight a very important development. The truth is that the truth is that in 2009, the Continental Mexico receives recommendations for the Continental margin in the Western Polygon. There's an alarm going on. I'm very sorry about that alarm going on. I don't know what the reason for that is. There is Mexico deposits the coordinates in 2009 with the UN Secretary General and with the Secretary General of the International Civil Authority as well in 2009. In 2000, so what I want to highlight in these two steps is that before we move there, the first submission took only 2 years between being made, being considered, and being approved by the Commission on the Limits of the Continental Shelf. The second submission that we made in the Eastern Polygon of the Gulf of Mexico was made in 2011, and it has not been considered to this date, 10 years later. So the fourth election takes place in 2012, the fifth election in 2017, and in 2017, under the leadership and the humble and modest leadership of Alejandro Alday, the Mexican delegation negotiated in a trilateral manner continental shelf boundary beyond 200 nautical miles in the Eastern Polygon. There were truly 3 boundaries agreed upon at that time, but Mexico obviously only agreed with the US and Cuba. The third boundary relates to the boundary agreement between Cuba and the United States. In 2021, we find an interesting development. We have find that the Commission has received an overwhelming 88 submission with 8 revised with a total of 96. We will comment on that a little bit. And of course, we do not have a date yet as to when our submission made in 2011 is going to be considered by the Commission on the Limits of the Continental Shelf. The number of submissions is without precedent in the history of the law of the sea, as we will see later on. So let us analyze the contrast between the 1958 convention and the 1982 convention. Whereas the first submission, the first article, the first convention speaks to a depth of 200 meters and beyond that limits to exploitability. Article 76 already, to begin with, speaks about the continental shelf to the outer edge of the continental margin. And then if that does not extend beyond 200 nautical miles, up to 200 nautical miles. The reverse could have also been done. They could have said up to 200 nautical miles, and in the case that the continental margin extends beyond 200 nautical miles, you could do that as well. They did it in reverse, and that is significant from our perspective. I am not going to go in great detail to explain Article 76, which in the course that we prepared for the Commission on the Limits of the Continental Shelf and the United Nations takes us about a week to try to talk to people about it. But I will say that basically when the continental shelf extends beyond 200 nautical miles, and I'm going to try to do it graphically for you very quickly, the foot of the continental plus 60 nautical miles and the foot of the continental slope up to a distance where 1% of sediment thickness is achieved are 2 entitlement formulae. In other words, if either one of those 2 extends beyond 200 nautical miles, we say that those are formulae of entitlement. In other words, the test of appurtenance, the continental shelf beyond 200 nautical miles appertains to the state that is making the submission. That is a radical difference with the constraints, which do not give you entitlement. They simply they simply limit the extent to which the outer envelope of the first two goes. So very often in books, you will find that some people and even professors argue that the continental shelf cannot go up to 350 nautical miles alone. That is, of course, not the case. It can go beyond 350 nautical miles, provided that the first two lines go beyond 350, but also the 200, 500 meter isobath plus 100 nautical miles is not exceeded. And the way we do it graphically is the first formula of foot of the slope with this continuous line, and 60 nautical miles gives us the first formula line. The second one gives us the same foot of the slope plus sediment thickness. Here we find a large amount of sediments that gives us a 1% limit that exceeds the upper portion. And then in the third step, we join this line and that line and find the outer envelope of the two. We refer to that as the formulae line. The same we do with the constraints. The constraints, we obtain 350 nautical miles, and then from the 2,500 meters above, we determine 100 nautical miles to find that second constraint. The same procedure applies. We obtain the outer envelope of the two. And we're going to use this outer envelope to restrict this outer envelope as we do in this scenario. This is our first outer envelope, our second outer envelope, and this envelope simply constrains this limit that is here. And if you understood those two slides, you're the proud expert on Article 76 from now on. From the perspective of Article 76, there are some exceptions. And in paragraph 6, we have the exception for submarine reaches. Reaches these days, as I see the practice develop, is an endangered species in the world. There is an increasing effort by states to try to argue that reaches are truly submarine elevations and they should not be subject to the constraints that submarine reaches are. So you will find very often submissions that allege that what is called in science a reach from the perspective of the submitting state is a submarine reach. Fortunately, Portugal nor Mexico have to deal with this issue. And of course, the last issue that I want to bring up to your attention is the last sentence of paragraph 8, where it says that the limits of the shelf established by a coastal state on the basis of this recommendation shall be final and binding. And there's a significant amount of uncertainty among many experts in the legal and the technical community, anybody that is involved in this, as to binding, final and binding on whom. Certainly on the state that made the submission, but even that state, in many instances, makes a submission with an agreement with another state that the submissions are done without prejudice to a boundary that is going to be delimited among them in the future. So in what sense, under those conditions, do these words apply of final and binding once the commission gives recommendation, the states adopts them? At what time do they truly become final and binding? And there are certain regions in the world, in the Gulf of Mexico, in West Africa, in what the Scandinavians call the banana hole, etc. There are a number of places where states have agreed to make their submissions with no protest whatsoever, notwithstanding the fact that it overlaps their maritime spaces, with the understanding that in the future, notwithstanding the recommendations of the Commission, in the future, competence relating to the delimitation of the boundaries will be among them. Last, I really have to mention the one topic that is usually left out in several presentations, and that is the statement of understanding concerning the Bay of Bengal. And it is because there's now a dispute relating to it, the interpretation of it. I don't expect you to read the full slide. I just want you to know that whereas the view of some states, particularly Sri Lanka and India, is that this provision applies to the Bay of Bengal. There are other states, and we have a submission now from the Republic of Kenya, which is adopting the statement of understanding to support its own submission, and it's in the consideration of the Commission on the Limits of the Continental Shelf now. So is Annex 2 of the final act intended only for Sri Lanka and India, or as Kenya would argue, it can be applied by any state, given the fact that the convention is a universal instrument and no specific state is mentioned by name. Of course, when we entered the third conference on the law of the sea, our understanding of the continental shelf and the continental margin was simple, was basic. This graphic that you see here is one that we inherited from the end of the 19th century to the 70s. At that time, the continental margin was understood mostly in morphological grounds. The tectonic processes associated with the development had not been discussed fully. And this was the scenario that the delegations had when they entered the third conference on the law of the sea. This book is dated 1973. You will see that that is the year of the first session of the third conference on the law of the sea. So as the conference evolves, there were several sessions that were key to the development of the continental shelf, of the part 6 of what now we know as part 6 of the Convention on the Continental Shelf. Sessions 2 and 3, and also sessions 7, 8, and 9 were critical to the development of part 6 of the Convention on the Continental Shelf. And at one time, in the 7th session, the secretariat of the conference was asked, what do all of these lines mean? What does it mean for the common heritage of humankind? What does it mean for many states to allow to extend the continental shelf beyond 200 nautical miles? And the secretariat of the conference gave a study to the Lamont Doherty Laboratory, one of the most famous institutions in the world, one of the best databases of hydrography and bathymetry in the world, to perform a study. And this map tells the story. This map was part of the report produced, and the areas that you see shaded are already included as part of the extended continental shelf that could have been implemented by any one of the formulae or the constraints presented throughout the third conference. The interesting conclusion at that time, we're talking about 1978, is that there was going to be a maximum of 35 submissions, that there was nothing to worry about in terms of the number of submissions or any potential encroachment on the area, the common heritage of humankind. Well, we know better now, and we also know that the continental margin, the development of continental margin understanding in science has evolved. This graphic by Clerk and others of 2019 shows what was our understanding in the 70s and 80s, how it moved from the 80s and 90s to a bigger understanding, and then a more profound understanding of the dynamics and the tectonics of these margins. Remember, the Commission finds now this type of science at a time when the conference had a much simpler morphological concept. So the scientific and technical guidelines had to be developed in 1999, and the training manual that was produced later on to take into consideration all of these factors. And it includes different types of continental margin and as important a role to geology as it does to morphology. So what has happened ever since? We have received 88 submissions plus 8 revised. That makes 96. Please remember, we erred by a factor of 3 in 1978. I would argue that a single submission today contains more bathymetry, more echo-sounding information, single beam and multi-beam, than the whole Lamont Doherty had in 1978 to make the study to estimate that only 35 submissions was made. There were 48 preliminary information notes received. 33 have become submissions. That means there's about 15 at least that need to become submissions, and 35 recommendations have made. Only 9 states, Mexico was the first. I'm very proud to say we were not the first country that received recommendations from the Commission, but we were the first country to adopt them, implement them, and deposit them with the Secretary General of the United Nations and the Secretary General of the International Civil Authority. So let me tell you a little bit more in maps about the situation of Mexico. From a geopolitical perspective, Mexico faces the Atlantic Ocean with a semi-enclosed sea, the Gulf of Mexico, which contains 2 pockets of high seas that are subject to the extension of the continental shelf beyond 200 nautical miles. It also faces the Western Caribbean Sea, but it doesn't face the open Atlantic. Mexico does not have a boundary with the area on the Atlantic side. Whereas in the Pacific side, I'm running ahead of myself here, we have an interior sea, the Gulf of California, which it's a single state interior sea, mainly consisting of internal waters, territorial sea, and exclusive economic zone. But we also have a maritime space that faces the Pacific Ocean and has a boundary with the area. In the very important Clipperton fracture zone, which is of great interest to the International Seabed Authority. So let's go and show you what happened and when in the Gulf of Mexico. First of all, we're very proud to say Garcia Robles, whom I mentioned previously as our delegate in the 1958 convention, was the Minister of Foreign Affairs in 1976, and by means of an exchange of note, and that is a strange, an unusual practice in several countries, but of course valid in international law, by means of an exchange of notes with the government of Cuba, determine a boundary up to the lower end of the eastern polygon. This is what we call the western polygon. This is what we call the eastern polygon. Those are high seas areas subject to the extension of the continental shelf of all coastal states in the region. The next boundary to be determined was the 1977 boundary between Cuba and the United States. And the last boundary to be determined is the 1978 agreement, and that contains two segments in the Gulf of Mexico and one segment in the Pacific that I'm not showing at the moment. So we have the Western polygon and the Eastern polygon. Everything is delimited up to that space, but the Gulf of Mexico is one of the areas with the deepest sediment thickness in the world, perhaps only second to the Bay of Bengal in the Indian Ocean. So there's more than 10 kilometers of sediment thickness. And the three states can extend their continental shelves beyond 200 nautical miles. The first agreement that took place by way of a boundary that I mentioned in 2000, and the order is important here. In the Western polygon, we first determined a boundary, and then in 2007, we made a submission. Whereas in the Eastern polygon, first we made a submission, and then we determined boundaries in 2017. And this is a place where the order of the factors does impact the result. In the first case, our submission could not go beyond the boundary. It means we had to arrive at the point in the boundary exactly without exceeding it. Whereas in the second case, just like Cuba does, and likely if the United States does at one time or another, in the absence of a boundary, they could have made a submission beyond the equidistant boundary, and then determine the boundary as we did in 2017. The case of Mexico is we made a submission first, and then we negotiated the agreement. Of course, we will abide by the terms of our agreement once it's final and binding on both states, and we will live happy ever after. So this is the extended continental shelf beyond 200 nautical miles of Mexico in the Eastern polygon. This is the Cuban, this is the US extended continental shelf. And on this side, on this polygon, only the United States to the north and Mexico to the south have anything to say. Mexico implemented paragraph 3 of Annex 1 to the Rules of Procedure. This is important. The convention doesn't say that states can make partial submissions, but the commission understood that in light of disputes and in light of the effort that needed to be made to prepare submissions, states could go progressively doing their work, and a partial submission was entitled. We also made a separate submission. We could have made a joint submission with Cuba, for example, and if the United States of America became a state party to the convention, we could have made a joint submission with them. That did not work out. The calendar of work of each one of the countries was different, and we were quite happy to be doing our work ahead of the other two neighbors, and we're happy to receive our boundaries. Of course, the third issue here is the cases of disputes. Sadly, this is a provision that was discussed, requested and discussed with the meeting of states parties of the Convention on the Law of the Sea to make sure that everybody was happy. And there was no objection whatsoever. So if you see legal arguments, every once in a while, a legal scholar says the commission did not have any competence to establish Annex 1 of the rules of procedure. And to do that, the commission was extremely conscious of how delicate these issues were. And it made its best endeavors to make sure that having prepared a draft of Annex 1 of the rules of procedure, it was submitted to the meetings of states parties for consideration. And if no objections were raised, it could then come back to the commission and adopt it. And it has functioned, it has worked out well to avoid the development and increasing disputes in a number of regions. So to conclude now, the continental shelf was documented in 1891. The legal of the continental shelf, the concept of the continental shelf appears to be born in 1945, and it was rapidly followed by declarations by Mexico and many other states between 45 and 52. The legal concept of the continental shelf begins to depart from its scientific counterpart in 1958, but now includes what we call the continental shelf in law, is truly the continental margin in science since 1982. The implementation of Article 76 with 96 submissions as a whole, original and revised submission, already long surpassed the total of 35 originally expected during the third conference in 1978, and we expect that number to rapidly increase beyond 100. Mexico has established 5 international maritime boundaries of the continental shelf, one with Cuba up to 200 nautical miles, one with the US up to 200 nautical miles, and then with the US beyond 200 nautical miles in 2000, and 2 boundaries, separate boundaries, with the USA and Cuba beyond 200 nautical miles in 2017. Using Annex 1 of the Rules of Procedure, Mexico has made 2 partial submissions in the Western Polygon in 2007, in the Eastern Polygon in 2011. We are still following the work of the Commission as the practice of the Commission expands. What is the precedent? What are the precedents that are established by the Commission itself and the states in establishing limits in the Pacific in order to find out whether there's any entitlement whatsoever by Mexico to extend the continental shelf beyond 200 nautical miles in the Pacific Ocean? And last, very proudly, Mexico was the first state to submit the list of coordinates of the outer limits of the continental shelf with the UN Secretary General and the Secretary General of the International Civil Authority in 2009. Thank you very much.
Thank you so much. Good afternoon. I would like first to thank the Director General, Alejandro Alday, for this partnership with the Diplomatic Institute of Portugal in order to have this webinar. And I'm going to ask now Professor Vasco Becker-Weinberg to have the floor. But before, I just wanted to tell you that he is a scholar, he is an academician that has dealt also into government. He served with a member of the Portuguese government related directly to this area. He now teaches at the Nova School of Law in Lisbon. He is the coordinator of the Master's Program on Law and Economics of the Sea. He has researched in different academic institutions and written and published extensively on the law of the sea and public international law. He has been a member, as I said before, of different delegations to international fora and advises on law of the sea and international law matters the Portuguese government. He's currently a law clerk at the Portuguese Constitutional Court, and he has worked with the Secretary of State of the Sea, and he is a full-time scholar at the International Max Planck Research School for Maritime Affairs at the University of Hamburg. So I will give him the floor. I will ask those attending this webinar that if they want to make questions, please write them on the Facebook and we will take due notice of them. Please, Professor Vasco Weinberg, you've got the floor. Thank you.
Thank you very much. Good afternoon to all of us here in Lisbon and to you in Mexico. Good morning. Thank you very much, Ambassador Freitas Ferraz, for that kind introduction. And of course, I'd like to extend my sincere thanks to you personally, but also to the Instituto Diplomático at the Portuguese Ministry of Foreign Affairs, and of course to Director Alejandro Alday at Instituto Matías Romero within the Mexican Ministry of Foreign Affairs. And thank you to all the colleagues that made this webinar possible. I will begin by sharing my PPT. I hope you can see it.
Yes.
Thank you. I will keep it quite short and to be able to stay within the time frame of 15 minutes. And I, of course, thank my colleague Galo Carrera for his presentation, which sets the stage for a more contemporary presentation on the issues concerning Portugal's continental shelf beyond 200 nautical miles. And of course, all the valuable information he shared with us sets really the core valuable knowledge we need to be able to discuss these matters. So I'm very grateful, and it's a pleasure to be with him in this webinar. I will just set the stage also in terms of timeline regarding Portugal's continental shelf beyond 200 nautical miles. And it is interesting to draw a comparison between the Portuguese experience vis-a-vis that of Mexico and other states, particularly regarding initial expectations, for example, dealing with the time frame, but also with technical and legal questions that were raised throughout the process so far. So when the process started in Portugal in 2005, a very important piece of this very complex jigsaw, technical and legal jigsaw, was and is the Task Force for the Extension of the Continental Shelf. And I use here the Portuguese acronym EMEPC. And it is a crucial, and as you will see in a minute, the setting up of this task force has had a game-changing effect in the Portuguese, but also, dare I say, international landscape when dealing with oceanographic research. And not only within the natural sciences, but also within social sciences, including law, for example. But not only, I would also dare say that it has had an important impact in other sciences, namely the economy, as we will also see in a minute. In 2008, a very important moment as well was the acquisition by the Portuguese government of a remote operating vehicle, iconically referred to as Luso, baptized as such, which has extended the technical possibility of depth reach by the task force, and therefore has been able to cover an extensive part of the Portuguese continental shelf beyond 200 nautical miles, including, and of course, its ability, its nature is, of course, to achieve 100% coverage. In 2009, May 11th, that was the decisive date when Portugal made its submission. And if we look at the numbers that Galo put forward, and we see that we are number 44 in that big line or train of submissions that is increasing, and we keep adding carriages to that big train of submissions. Portugal presented in 2009. And later on, we presented an addendum to that submission made in 2009, where basically we added new but also consolidated information of bathymetry, geology, and geophysics data and other relevant information. Recently, a few days after that, the submission of the addendum, we began interacting with the subcommission, albeit these exchanges have so far been suspended due to the pandemic situation, which is affecting every member state in dealing with the United Nations and the work of the United Nations as such. But hopefully, as soon as the situation is safe to start interacting and the work of the UN starts full steam ahead. I'm sure we'll pick up exactly where we have left off. So what I'm showing you now is a map of, which is the map resulting from the addendum. And I'm not sure if you can see my mouse on your screen, but if I can present this very clearly. What you see here in black and white is the extended continental shelf or the outer continental shelf limit beyond 200 nautical miles. What you see here in green is the limit of the Portuguese EEZ in this area in the subregion of the Azores. Here you have the limit of the EEZ projected to the north that is relevant regarding the subregion of Madeira, and then here the mainland of Portugal. The smaller lines here in green, closer to the mainland, of course, are the baseline of the mainland. So in essence, if you imagine the Portuguese map, and if you can locate the Portuguese map, and I will make this more realistic in a minute, you will see that it's quite a significant part of the north basin of the Atlantic Ocean that Portugal proudly exercises rights of jurisdiction and sovereignty in such a large area. Of course, Portugal is very much aware that with this sizable rights that it has, of course, entails significant and important obligations. So what has been the main deliverables of the task force? And this is my personal view, where I believe the task force has had that game-changing effect that I mentioned earlier. And I probably will stop here for 1 minute reflection on this matter. If most countries, when they approach the issue of making a submission, they're faced with a very difficult decision, because a submission entails a significant amount of resources, human resources, financial resources, and material resources. Human resources is finding the experts within your country that are able to assist you, and if you don't have them, my suggestion is to initiate a capacity building process in order to achieve that. In the case of Portugal, this has had a tremendous effect. What is the task force and the valuable human resources that work within the task force has had a domino effect in enlarging the scientific community in Portugal and the interchange between that scientific community in Portugal and the wider and global scientific community. The other issue, of course, and it's a decisive issue, is financial and material. Being able to fund oceanographic missions, being able to fund the acquisition of equipment. These are crucial decisions that have to be made at a very early stage. But if with the benefit of hindsight, if we look back to 2005 and the road that the task force has done so far, we can only be extremely proud of the work that the Portuguese task force has done, because it has had a game-changing effect. And I've highlighted 5 examples, and I could go on, but for the sake of brevity, I will only refer to these 5. The first aspect is ocean literacy. Everybody now in Portugal has the map of Portugal's continental shelf in their minds when they refer to the ocean. So not only projecting that very strong image, but also across multiple sectors and at different layers of civil society. There are many programs that are being developed, not only at a very senior level, but also at a very, very junior level. Technological development and significant increase of capabilities. I somehow brushed upon this, and I believe this has been one of the major achievements of the task force. But there are tangible and significant deliverables. For example, in 2006, the identification of Rainbow hydrothermal vent field, and which is the first NPA beyond 200 nautical miles globally, and in 2010, additional NPAs beyond 200 nautical miles, and which only these encompass more than 119,000 square kilometers, and there are many other efforts in classification and protection of marine protected areas within the Portuguese national maritime space. I've also brushed upon the importance of scientific and academic exchanges, and currently, just to highlight how this has had a very powerful impact in Portugal. Portugal has now the second highest ratio of ocean science researchers per million inhabitants, and this is after Norway and before Sweden. I'm sure that in 2005, we were not able to predict that we would be as successful as we have been so far. So I believe that the future is actually extremely promising beyond the submission itself. In addition to MPAs, Portugal extension of the continental shelf has had an impact also in dealing with other area-based management tools. And here I'm referring to marine spatial planning. And in particular to the newly founded concept in 2014 of the national maritime space, which includes the continental shelf beyond 200 nautical miles. To underline what I just mentioned, which I think is one of the key issues in terms of pushing the envelope forward in terms of ocean governance that Portugal has been a leader so far. Portugal has legislated on the use of the continental shelf beyond 200 nautical miles, pending the submission before the CLCS. This is a quite intricate and complex legal issue that has to be analyzed quite carefully, but it actually did raise the bar higher in terms of legal development. And this was only possible with the extension of the continental shelf and the ambition to develop a very strong and robust marine spatial planning instrument. And this is as you can see, I always mention the sources of the maps I use, so feel free to Google them, and I'm sure you will be able to track them down as I did. And this exemplifies what is Portugal's EEZ. As you can see, the Azores, Madeira subregions, and the mainland. And here you have what is the extended continental shelf area. This is prior to the 2017 addendum, if you recall. So this reflects what was the 2009 submission. And here you have the EEZ and the extended continental shelf put together. So it gives you a very broad perspective, but I think this one actually does the trick. If you compare the size of Portugal's mainland vis-a-vis the area where it exercises rights and what we define legally as Portugal's national maritime space, and there you compare it with the mainland in Europe, it is quite striking in terms of the overwhelming responsibility that Portugal has undertaken, and I think it's quite brave of us to do so. And here I've added more complexity to the matter because this is one of the key conclusions that I would like to bring to you. Here in this map, you not only see the interior waters, you see the contiguous zone, the territorial sea, the EEZ, the continental shelf within and beyond, but you also see the search and rescue area that Portugal has, which Portugal is responsible for. So it is quite significant. And of course, it commands a lot of effort and resources. And of course, it is quite promising in terms of what we can do in the future. The other important instrument that I would like to draw your attention to connects the extension of Portugal's continental shelf and marine spatial planning beyond 200 nautical miles. So as I mentioned, Portugal was the first country to really develop a marine spatial planning, not only existing legally, or as some skeptics would say, on paper merely, but actually is being implemented. If you are able to track this down using any research tool online, you will find the geoportal of Portugal's marine spatial plan. And this is available in the DGRM website of the Portuguese government. And this is an interactive instrument that shows you exactly what is happening, not on the ground, but at sea. And you have different layers. I've simplified this for you, although it doesn't look like it. But if you look at this for a second, you will see that I've identified not only submarine cables and pipelines that go through Portugal's national maritime space, but also areas that are now under international legal protection, particularly marine protected areas, but also other legal regimes, and many other usages and activities. So instead of conclusions, I decided to highlight 4 challenges that we face when extending the continental shelf, not only in the case of Portugal, but I would assume that these challenges are common to most states. How can we address the legal challenges in implementing MSP beyond 200 nautical miles? And this is particularly difficult because when we are dealing with MSP within 200 nautical miles, we are, in most cases, interacting, if not all, interacting with the EEZ. Whereas when we are dealing with the continental shelf beyond 200 nautical miles, we are dealing with the high seas. The second challenge or reflection that I would like to share with you is how can we integrate multiple regimes, legal regimes, and achieve legal and coherent solutions, for example, vis-a-vis NPAs. And this is particularly relevant in ongoing international legal processes. And how do we integrate area-based management tools within the new implementing agreement on BB&J? This is extremely difficult and quite challenging issue, in addition to all challenging issues that are included in the BB&J package that we have to deal with. And how to achieve consistency between rights of sovereignty and jurisdiction of coastal states and the overall interests of sustainable ocean governance. And here I believe that Portugal can provide a good case study, not only in terms of legislation, but also of legal and technical practice. And I will go back to where I began, the importance that the Portuguese task force had and is having in contributing to new legal and scientific and technical solutions that we are now just seeing the benefits of the investment that has been made over almost 15 years. So I will stop here and thank you very much for your kind attention, and I look forward to any questions you might have. Thank you.
So thank you so much, Professor Vasco Becker-Weinberg. The Director General, we already have 2 questions. Do you want to refer to them?
Yeah.
Okay.
The first one is from Joaquin Matos.
Yes.
And he says, after 2 decades since the creation of the Commission on the Limits of the Continental Shelf, what is your assessment of the role and work of the Commission, particularly when considering the initial estimation regarding the number of submissions? I don't know if we can tackle down this one, and then the experts can go to the next one. We have already 2.
Yes. So,
Galo, would you like to start?
Of course, sure. Very happy to do that. Of course, the main problem envisaged in the not only relating to the map developed in 1978 and that established 35 submissions, went beyond that. Annex 2 to the convention establishes the regime for the establishment of the Commission on the Limits of the Continental Shelf, and it was very restrictive. It's the only body created by the convention that does not have its own secretariat. Members of the Commission do not receive a salary. They do not work full-time. It was envisaged to be, nobody knew what a submission was. And in the absence of information as to how many years a state would invest in preparing a submission to extend beyond 200 nautical miles, and only 35 submissions being estimated to exist, it was supposed to have been a brief undertaking. If anybody had said that it was going to take more than 10 years, we would have been called as exaggerating at the time. Well, if you consider that there are states that have spent more than 10 years preparing their submissions, some have spent hundreds of millions of dollars in the preparation of their own submissions for a very long time, and the Commission only meets a maximum of now 21 weeks a year, the outcome is to be expected. There is a tremendous backlog, and there's no deadline for some states to even begin to consider the preparation of their submissions. That has a dramatic impact on the submission and the states themselves, because if you made a submission 10 years ago, by the time it's considered by the Commission, you will have to amend it. You will have to revise the data that you prepared. You will have to update the software that with which the submission was prepared to make sure that everything is compatible and updated. There are a number of problems that were not envisaged by as a result of the underestimation of the work of the Commission. To this date, the Commission still brings the issue regularly to the meeting of state, the attention of the meeting of states parties, to highlight the need for better conditions of work, for to spend more time in New York. But to this date, I don't think even health insurance is something that is provided to the members of the Commission. So, what is the assessment of the situation? That it was underestimated, and it has not changed. And the only solution to that problem is in the hands of the meeting of states parties itself, which has to give some greater permanency to the Commission, better conditions of work, and to basically restructure some of the arrangement established in Annex 2 to the Convention. Thank you.
Thank you. Vasco?
Thank you very much for that question. Very interesting question. Well, I share some of the concerns that Galo mentioned. Those are not new concerns because we are seeing them now. For example, in the context of the BBNJ process, we also have an issue whether there will be a secretariat, where will that secretariat be, how will it be financed, where will it be based, how will it be run. And there are many complex issues, but I believe those are part of the realm of international organizations. But I share the view that we can share that view because we have the benefit of hindsight, that if the drafters of the convention knew then what they know now, they probably would have drafted different solutions. But that is a difficult matter. And of course, I believe that this is part of the multilateral processes. And of course, we have to remember that if we look at the drafting of the convention, and we look at the many documents that are now available online, so for those that are interested, you can access them online. And there is a very good commentary published a few years ago, in addition to a formal one by Virginia. You can actually see how some issues were dominant during almost one decade, and others were not at least touched upon, and how this different balance of priorities existed at the time, and it is completely reversed now. So I think that that's just one of the challenges that we that interpret and apply the convention have to deal with in our small scale or larger scale. But it is a challenge. And I agree that some issues will depend ultimately on a decision by the states parties.
Mm-hmm. Shall we go in for the second question?
Yeah, there's another one. I wonder whether if Professor Vasco would like to start in providing some response. It's related to the BBNJ agreement, considering the challenges ahead. For example, the new implementation agreement of UNCLOS for the BBNJ, the conservation and sustainable use of marine biodiversity in areas beyond national jurisdiction. How would you see the further development of the role of different law of the sea bodies?
I think that this third question also somehow connects with the second question and was mentioned briefly, I think, by Galo in his presentation, I believe, when he mentioned paragraph 8 of Article 76. This is probably the biggest challenges that we are facing. Not only in dispute settlement resolution, and we have a classic, first and classic case of Bangladesh, Myanmar, where the issue was raised regarding the roles of the CLCS, roles of dispute settlement mechanisms, and how they interact with each other. And it's not an issue that is peacefully accepted by international academia. There are other or different visions on the matter. I tend to agree with the content of that decision. Regarding the BBNJ process, is quite difficult. Also, because of the essence of the multilateral process that we are dealing with. The BBNJ negotiation process is very different from the convention process. We are seeing a larger intervention by civil organizations, non-governmental organizations, other stakeholders, in addition to a different level of states interacting. There's also a complex issue that is being approached differently from the convention. That is the scientific approach to the matter. I'm sure that probably back in the 70s, we would have it would have been very useful to have some sort of scientific translator to adjust the legal text. But this is a struggle that I think that we have to deal with. As long as there are lawyers, I think that most scientific colleagues will always struggle with that, and vice versa. So I think that in the future, we will see what will be the role of, for example, of the International Seabed Authority as well. How will that interact with the new body under the BBNJ implementing agreement? Regarding the CLCS, it's extremely relevant because not only are we now in a process where submissions are piling up, so the extent of the area, it will not probably be known in my generation, I believe. It will take longer than that, perhaps, unless we find another solution, the states parties, which I have some doubts. But also now we have to put on top of this the interaction regarding BBNJ. And here the key element is how can we integrate different legal regimes, the rights of coastal states beyond 200 nautical miles, vis-a-vis the high seas and now the new BBNJ implementing regime, and then the horizontal connection between the outer continental shelf, the area, and here it's Article 142 of the Convention gives us some inclination, and then how do we interact these two different regimes in areas of complementarity with the new BBNJ regime. So I think that there are many challenges ahead, and there are many valuable questions that hopefully future PhD theses and other research deliverables can actually provide. Thank you.
So, thank you so much. Do we have more questions? Any questions at the Facebook?
Ambassador, I wonder if Galo
Yes, of course.
provide some thoughts on this
sure.
very complicated question and the process.
Well, there were two questions really linked one with the other. The first one was made by Francisco Oliveira, and he said, how do you see the complementarity of the mandate of the CLCS and the role of other bodies, for example, in international dispute settlement? And the answer is, unfortunately, the drafters of the convention did not envisage a formal form of communication between the Commission on the Limits of the Continental Shelf and the International Tribunal on the Law of the Sea. Of course, the tribunal can call upon experts in accordance to its own statutes and so on. But I do wonder if it would have been possible and perhaps even preferable to seek the assistance of one another. There have been instances where the Commission on the Limits of the Continental Shelf has requested at least twice opinions from the Legal Council of the United Nations relating to the additional materials and the legal status of members before the United Nations. It was Commission members were declared as experts for the United Nations. It would have been useful, perhaps preferable, to request those opinions from the International Tribunal on the Law of the Sea, and also where the tribunal makes a decision, such as the one mentioned by Vasco in the case of Myanmar, Bangladesh, for example, where entitlement is at stake. Who does the tribunal rely on in order to prove that that is indeed the case? That was a relatively simple case because we knew from the time of the conference that the extension of the continental shelf was granted in the Bay of Bengal beyond 200 nautical miles. But I am sure that there will be other instances where the Commission has not made a submission, recommendations relating to a submission, where one state takes for granted that it can extend beyond 200 nautical miles, and not only that, to what distance, and if the only option that the tribunal has is to leave those lines with an arrow pointing beyond 200 nautical miles, I do wonder whether all the relevant elements in a submission are taken into consideration in order to define that with greater certainty. So it would have been preferable for the Commission and the International Tribunal Law of the Sea to have a great deal of communication. There would have been instances where the International Seabed Authority could have made inquiries in order to begin to award permits in certain areas as to whether the Commission saw the possibility of entitlement beyond 200 nautical miles before any neighboring state could have made a submission in that area. And it's something like equivalent to what an advisory opinion would be given by an international tribunal or the International Court of Justice. It would have been useful for one body to request the advisory opinion of another one and interact in that manner. That did not happen. As to BB&J, I am greatly concerned. I am greatly concerned about the course that the negotiations have taken. I think that it is positive indeed to take into consideration the role of non-governmental organizations and civil society, but at the same time, any time that there's a temptation for the new generations of delegates to not remember the framework provided by the UN Convention on the Law of the Sea, we get in trouble, number one. Number two, one of the main motivations for me, great expectations of the BB&J conference was the allocation of genetic resources in the seabed, perhaps under the administration of the International Seabed Authority as part of the common heritage of humankind. Instead, the BB&J has taken an environmental emphasis and has taken away, and it's now a very remote possibility. There is a very remote possibility that an agreement on genetic resources, which I thought was one of the greatest priorities of these negotiations, is fading away. So I would stop here.
Mm-hmm. Thank you so much. We've got a last question. What are the expectations for state submissions given the workload of the CLCS? Who does want to start answering?
I think I can start right away because we face that. There are two bad signs, I have to say. It's not only about the workload of the commission and the conditions and the periods and all of that. It is the states themselves for two reasons. There is a submission that I know about. You can check it in the website. I'm not saying anything confidential. When I mentioned, for instance, the submission of Myanmar. Myanmar made a submission way back when. It's the oldest submission that has been objected against by Bangladesh. There was a case that went to the International Tribunal of the Law of the Sea. There were cases that there was the Bangladesh-India case. The issues of boundary making have been resolved. And yet, for some reason, Myanmar does not see that the Commission can look at the submission. So these disputes, and there are, we didn't address that issue. There's simply not enough time in this presentation to address the number of disputes that exist around the world. Mexico paid great attention to the fact that that would not happen in the Gulf of Mexico. So we made great number of consultations with our neighbors, and that is one of the reasons why there are two partial submissions instead of one. And but the states themselves have not facilitated sometimes the arrival of some of these older submissions that should have been considered. The other issue that affects the work of the Commission, of course, in terms of expectations, is the fact that states, when they are waiting for their submission to arrive, are eager to get there. But when they get there, they have the prerogative to adopt a position to interact with the Commission for as long as it takes, so that the consideration of the submission is done to the fullness of their satisfaction. That means that the back and forward between subcommission and state can go on for several sessions until all the avenues have been exhausted. Instead of having given the Commission adopting the possibility to terminate the consideration of a submission, the process seems to have taken an inertia of its own that allows states, once they have their submissions considered, stay on top of the consideration of the submission for considerably longer periods than it did before. So it is not only the Commission or the framework, but the conduct of the states that affects expectations. And I would hesitate to give a deadline to announce to the government of Mexico itself when the next Mexican submission is going to start. And it's only a few away. It's no more than 5 submissions away in between the pandemic and the workload of the Commission. And for example, the Indian submission was already halfway through the consideration by a subcommission, and an objection was presented by another state. That means all of that work has to be put aside now and start with another submission because the consideration of that obviously sends the commission back again to do this kind of work. So it is not only the convention or the framework or the ability of members of the commission that I know work very hard, and I have great sympathy for the many weeks that they spend away from their families. By the way, Fernando Pimentel, Portuguese member of the commission, was a member of the subcommission who considered the Mexican submission in the Western Polygon, and Aldino Campos is doing a fantastic job. I know he has a young family. It is a great sacrifice. I wish to convey to everybody that is listening to us today that those 21 members in the Commission on the Limits of the Continental Shelf work far more than the 21 weeks that you see on paper. There are weeks in advance that you have to prepare to go to New York to consider submissions. And then there are weeks after each session where you have to follow up with the states about the new data that was submitted to you and issues that have to be considered. So if anybody's under the notion that members of the Commission only work 21 weeks a year, there would be no bigger mistake than that. And I have a great deal of respect and admiration for the great members of the Commission that Portugal has submitted. Fernando Pimentel was a great hydrographer, and Aldino Campos was the chairman of a subcommission that I had the opportunity to work with, and I think he's a magnificent member. So, felicitações, recomendações aos meus amigos brasileiros, portugueses.
Professor Becker-Weinberg.
Yeah. Well, I'd just like to say something because try to balance some of the comments that were made. These are issues of sovereignty, and these are delicate issues, and these are issues that every government has to deal with quite not only diplomatic and legal care and technical care, but also political care. Governments have to win elections. The states have public opinions, and they have to, of course, when dealing with issues of sovereignty, which are extremely complex and delicate, make sure they explore every avenue. So I would probably will not look in sharing blame, but probably I would say that this is the reality of international law, and this is what we have to deal with. I'm not sure if increasing the number of commissioners, if changing the rules, which I would probably not suggest at this point, but some solution might be dealt with or by member states. But again, member states, those are the ones that have the tools in their hands, can come or not to a solution that changes the current paradigm. But to give a very straightforward answer to the question that was raised, what is my expectation? Well, that we in Portugal, as a Portuguese citizen, I would share the expectation of all my fellow countrymen and countrywomen, that we actually will see that we are fully recognized and that our submission is fully acknowledged as being scientifically and technically well-founded and correct, and that is my expectation. I'm sure that every person would feel the same regarding their own country. And of course, I thank and I share the views of Galo regarding the current and past members of the CLCS. I've had the pleasure of meeting many throughout the years, and they go through extreme lengths. And I always share the stories of those coming from countries where they have little or no resources, living all those weeks in New York, which is an extremely expensive city, of course, and there are many intricate elements to that relationship. However, I believe that that's an issue for each member of the Commission to deal with its own member state, and it's not an issue that should, again, these are issues of national interest and sovereignty, and we have to tread upon them somehow carefully. And of course, being a Portuguese, I would always venture that my country would do the utmost to when it comes to defending our national interests, including in the CLCS. So thank you very much. I'm not sure if there will be any more questions. I'll probably just end here. And thank you again, Instituto Diplomático and Instituto Matías Romero for the kind invitation. It's extremely extraordinary. Just one personal note, I shared the panel with Galo Carrera 10 years ago in Seoul. So, and he looks the same, much better than I do. So it has been a pleasure to see you again, Galo. And I wish you all the best. And thank you all, and for those listening and sharing their very thought-provoking questions. Thank you.
Thank you, Vasco. Thank you so much. We don't have more questions. I just wanted to make 2 points. The first one is, of course, to thank the Instituto Matías Romero and its Director General, Alejandro Alday. And the other one is to thank, of course, our today's speakers, Galo, Carrera, Hurtado, and Vasco Becker-Weinberg. The second point has to do with the respective interests of both Mexico and Portugal regarding the law at sea, regarding maritime affairs. Mexico has a coastline which is about 10,000 kilometers long. Mexico has been dealing with these questions for many, many years, as Galo Carrera so eloquently made clear. And Portugal, of course, because of our strategic position, because of the 2 archipelagos, is also very much interested in those matters. I would like to propose, it's not a formal proposal, but to see the possibility that in the future we came out with our institute and yours with a special number of our magazines regarding the law of the sea and regarding the subjects that were taken up today. So once more, thank you very much to everybody, and I'm looking forward to keep working together with our colleagues from Mexico. Thank you.
Thank you very much, Ambassador. From our side also, it has been a pleasure to work with the Instituto Diplomático in these matters that we love very much, the law of the sea and the opportunity to share with our young diplomats from the view of consolidated experts what is going on out there in terms of the negotiations and the implementation of parts of the convention. I thank you for your proposal. I will look carefully for this possible publication on the law of the sea. I think for us will be a pleasure to consider that. And finally, I would like to thank Galo Carrera and Vasco Becker-Weinberg for your excellent presentations, and to congratulate Portugal for the re-election of Antonio Gutierrez as a Secretary General of the UN for the next 5 years. It's a very important news for your country and for the whole United Nations. Thank you very much.
Thank you. Goodbye. Thank you so much.
Thank you all. Bye.
Gobierno de México.